Do it again. This is Unit 5. First off, I'd like to congratulate all of you for making it to the Nationals.
Thank you.
My name is Don Wheat-Martian. I'm an attorney from Zanesville, Ohio.
I'm Rosemary Traub. I'm a domestic violence hearing officer for the court in Albuquerque, New Mexico.
And I am Edward Volpe. I'm an attorney from Denver, Colorado.
And you are.
Thank you for allowing us to testify before you today. We are a unit composed of all juniors from East Grand Rapids High School, and my name is Elijah Becker.
I'm Lily Schreiner.
I'm Ethan James.
I'm Belle Gorsline.
I'm Henry Vanderzijde.
I'm Sophie Forstner. Our coaches are Adam Horst and Benjamin Langholz, and we're Unit 5.
All right, we're going to do question number 3. It's been 50 years since the landmark case of Tinker v. Des Moines. It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the State House gate. Since Tinker, have the rights of students in public schools been expanded or limited? If the time has come when pupils of state-supported schools, kindergartens, grammar schools, or high schools can defy and flout orders of school officials to keep their minds on their own schoolwork, it is the beginning of a new revolutionary era of permissiveness in this country fostered by the judiciary. Do you agree or disagree with Justice Hugo Black's dissent in Tinker? Why or why not? Should students suspected or accused of breaking school rules have the same due process rights as juveniles or adults accused of crimes? Explain your position. All right? You may begin.
As Justice Fortas famously opined in the majority opinion of Tinker v. Des Moines, in our system, state-operated schools may not be enclaves of totalitarianism. School officials do not possess absolute authority over their students. Students are persons under our Constitution. Although the decision in Tinker was intended to grant students more speech and expressive freedoms in schools, we hold that numerous succeeding cases have limited these rights.
Since the Tinker standard was established, students' free speech rights have been limited by countless cases. In Bethel School District v. Frazier, the court used Tinker to allow limits on speech inconsistent with schools' values. Later, jurisdictions were expanded to include school-supervised events in Morse v. Frederick. Schools continue to gain a significant amount of authority over their students, leading to a limit on students' expression. For example, in the lower court decision, Dariano v. Morgan Hill Unified School District, it was ruled that it is constitutional for officials to limit student speech based on only a prediction that a disruption could occur.
In addition to free speech rights, Fourth Amendment protections have been continuously limited as well in schools as well. In the landmark decision of New Jersey v. TLO, it was established that teachers need only a reasonable suspicion to search a student. Students' rights were further constricted by cases such as Board of Education v. Earls, which ruled that schools are allowed to drug test students who elect to participate in extracurriculars, and Bernoni v. Acton, which similarly opined that student athletes may be constitutionally drug tested randomly, stating that the reasonableness of a search is judged by balancing the intrusion on the individual's Fourth Amendment interests against the promotion of legitimate governmental interests.
We disagree with Hugo Black's dissent in Tinker. The student's symbolic speech was allowed in Tinker because it was a silent, passive expression of opinion, unaccompanied by any disorder or disturbance on the student's part, according to Justice Fortas. The wearing of armbands was not just disruption for the sake of not doing schoolwork. It had an important political message against the Vietnam War. Additionally, Justice Black's assertion that Tinker allows pupils to defy and flout school officials has been proven untrue. Where students discover innovative ways to defy their administrators, more limits are enacted.
When students defy rules, beneficial change can be made. In West Virginia v. Barnett, students demonstrated this when they refused to stand for the Pledge of Allegiance, and without this case, we may not have the constitutional protection against compelled speech in school. In Davis v. County School Board, students organized a school strike to protest terrible conditions and a lack of funding in an all-black school. This was ultimately combined with Brown v. Board, which evoked the termination of the separate but equal doctrine.
Though it is important for students to be able to practice their rights in order to contribute to society, they should not have the same due process standard as juvenile or adult alleged criminals. The amount of due process given is proportional to the amount of rights that are deprived. Juveniles and adults accused of crimes face much larger deprivation of rights, like jail sentences. Thus, they should be given a larger amount of due process than students in a school setting.
Students, however, are entitled to certain due process rights. We agree with Goss v. Lopez, which requires that students go through a hearing before facing suspension. When the right to education is stripped from students, they are entitled to some procedural due process rights. These rights include not only a formal hearing, but but also the ability to have legal counsel, a private hearing, and the incorporation of evidence and witnesses in the case of a long-term suspension or expulsion.
The ability for students to largely maintain their rights in schools is important. Students will grow up to be the primary contributors of society, so it is vital that they are able to both understand and practice their rights in a public setting. Although schools should be able to protect their students and maintain the safety of the school, there should be a reliable standard that ensures all schools limit students' rights in the same manner. Thank you. We are now ready for your questions.
With regard to the decision in Tinker, if the facts had shown that other students were angered by the presence of the armbands and that there was a serious argument going on in the threat of violence, do you think the decision in Tinker would have been different?
I think that could have had a different result, as seen in the lower court decision Dariano v. Morgan Hill Unified School District, where there was a previous past of racial tensions at a school, and then on Cinco de Mayo, several white students decided to wear American flag t-shirts, and they were prohibited from doing so because of the underlying racial tension that could occur and the threat of violence that could happen to the school environment.
And we see that, as Justice Fortas wrote in his majority opinion, that the students did receive an amount of backlash for their political speech. However, in essence of political speech is that it is given not solely for the intent of disruption, but to promote an idea that may be controversial and may not be accepted, but is still important to put the idea out there.
And for this reason, we see that sometimes schools are, it's needed for them to be subjective in understanding whether or not the students were trying to put forth a legitimate idea or whether they were simply using the speech to create a disruption.
Do all the protections that you've all just mentioned apply to students who are illegal immigrants? Should they apply to students who are here illegally?
I would argue that they should apply to illegal immigrants that are students as well, because these students are participating in that education, and because they are under the school's supervision while they are attending that school, the school has the duty to protect those students, and thus they should maintain those rights despite the fact that they may in fact be illegal immigrants.
And we see that the nation has started to move towards trying to give the same rights to illegal immigrant students as they would students that are citizens, as now in places such as San Francisco, they are moving to allow parents to vote in school board elections for their students if they're attending the schools.
Someone mentioned the right to counsel in case of severe expulsion or suspension. What if you couldn't afford counsel? Who pays for it?
In schools, if you cannot provide your own legal counsel, it will not be provided for you.
However, outside of schools, under the Fifth Amendment Due Process Clause, legal counsel will be provided, but obviously we see that here in schools there is slightly less due process, and slightly less rights are being deprived.
However, in schools, despite not being guaranteed legal counsel, you are guaranteed a panel hearing if they're in the case of a long-term suspension or expulsion, and with that you are also able to be informed of what you are being accused of and charged for, and before you take part in that panel hearing.
I believe that the right to have a counsel provided for you that was established for outside of the school environment and Gideon v. Wainwright should be applied to inside the school to not discriminate against students of lower economic classes who could not afford to provide a lawyer.
I would also argue that students should be provided a panel of their peers, which removes some bias from teachers or other administrators.
And to go back to what my colleague said, the students are afforded to be notified of their alleged crimes and given a hearing, and that was established in Goss v. Lopez.
May students be punished for behavior of their parents? For example, if parents refuse to get a child vaccinated, may that child be excluded from school?
In my opinion, yes, that child may be excluded from school because the state has the necessity and the compelling interest to maintain the security of the school and to maintain a safe learning environment for schools. So something such as an unvaccinated children could pose a health risk to the children around them.
I would say that they should not be excluded because, as seen in Meyer v. Nebraska, it was decided that parents can raise their children as they see fit, And so I believe that if the parents believe that their children do not need vaccinations, then they should be able to attend school that they wish.
However, in private schools, they may be able to require all students be vaccinated because they're not working under a public setting.
Does the due process, as explained in Lopez, apply to private schools?
As private schools are not a public institutions such as schools are limited by the First Amendment and other government regulations. Private schools do not necessarily have to follow the due process standards that are inscribed upon public schools.
What if they're receiving government subsidies
If they're receiving government subsidies,
or scholarship money, scholarship monies?
then in my opinion, I believe that yes, since there is the entanglement of the state with that private school, then they have a duty to follow the restrictions that the government has imposed upon them.
Private institutions also put forth their own rules about what due process standards they will follow, and then they are required to follow the standards that they have published in the student handbook or in other places.
And since students of the private schools are electing to attend that school, then they are subject to follow the rules that the school has already set forth rather than the public laws.
Tinker focused on First Amendment rights, freedom of speech. New Jersey versus TLO focused upon the Fourth Amendment, the right to privacy with regard to your locker and those kinds of things. Does it extend to protection of the student's body? For example, if someone is suspected of possessing drugs, may they be strip searched?
No, students are not able to be strip searched. It was established in Stafford v. Reading that the school is not able to use any searching means that would be violating shocking to the student's conscience.
Okay. How about a round of applause for this panel?
Just juniors?
Yeah.
You're back next year?
Yeah, coaching.
Very nice pacing among yourselves. Very good interaction, picking up on other people's clues. Did a very good job reacting to our questions and reacting to each other. It's very, just sometimes people want to rush through the presentation. You did a very good job. We could hear you, we could understand you. You knew your stuff. And you let us know you knew your stuff and we could understand. Good job.
Thank you.
I think you did a good job of right out of the box answering the questions, and that's obviously very important in this. And just same comments. I mean, your flow was good among the six of you, and I think that's not easy.
It's very hard for
You
six.
know, to do that with six people. And but the flip side of that is that you each had your own kind of separate quality, in the way that you came across. So I thought that was, went along with that. And so you didn't all sound the same, and you had a little bit different variations on a few topics. I thought you had very good command of the case law and were able to discuss it well. Nice job.
I too enjoyed your presentation. I enjoyed the balance across, a six-person panel, which is not easy. We certainly see different situations on different teams. With regard to your knowledge of the actual legal background, I thought you did a good job of talking about some very important cases. You cited Meyer versus Nebraska, which actually ruled that the state could not ban the teaching of German during the First World War. So the right to an education extends to subject matter as well as to just being in school. The whole idea of the various bills of rights, the provisions with regard to personal protection, certainly we've talked about the First Amendment, we talked about the Fourth Amendment. Strip searches, of course, have been prohibited in Stafford School District versus Reading. The courts simply aren't going to allow school officials to go that far. If they suspect drugs, they probably should call civil authorities, the police, and have someone come in. But you are to be congratulated on your hard work this year. You've done a good job. You presented yourselves very well with good background. That says something about your teachers and how well they have done with regard to this. But more importantly, you've been given knowledge that I want you to go forth and use in our American society and in support of our government. I've told other teams, and I'll tell you, you know more than 95% of the voting public as a result of participation in this program. And look what I'm looking at back here. Look at this community support. Think what they're telling you. They're telling you that this is important. They're telling you that you are important. I want a round of applause for all this community support. And keep in mind you didn't get here all by yourselves. A round of applause for your hardworking teacher.